Everyone, welcome to our mid-year law update. We are super excited because there's a lot going on, and I know this has been a year crazier than most. So instead of having you sit behind your desks trying to figure out all these rules changes that are happening around the country, we thought we would do our mid-year law update for you. And so there's going to be a lot of information that we're going to get through, but there's some really new stuff that's coming to light, some things that we talked about in January that we're going to talk about again because many of you, haven't necessarily enacted a lot of these and haven't taken steps to make sure you're compliant with them. So we want to make sure you have the latest and greatest. And then there are some new law updates, actually, things that have been passed recently that you should know about. And so we're going to talk about that as well. And then finally, we're going to end on how to really prep for the second half of the year. And it's crazy to even think that we're talking about the second half of the year because it being July, it feels like we are still in the early parts of 2023, but before we know it, the end of the year is going to come by pretty quick. And so it's important to take some steps, in the second half so that we are rock and rolling and in compliance leading into the end of the year. As those of you who don't know me, my name is Ali Oromchian. I am a dental and medical attorney. We work nationwide on practice transitions, lease negotiations, partnerships, sales of practices. We do a lot of employment law, of course, which is one of the reasons why I created HR for Health many years ago to allow you to have a tool that keeps you compliant with all these really crazy restrictions that are out there and all these new compliance obligations that practice owners have. And so that's what I do, and I'm happy to be here with all of you because we usually do this only twice a year, and so it's an opportunity for us to summarize all the rules changes that are happening year round so that you don't have to, and so this is a good cheat sheet for you. All right, so let's start off with some minimum wage information and then some changes on hiring and onboarding. Because as most of you know, when we are talking about the basics of HR compliance, the basics start with hiring, right? With hiring, and if you're not doing your hiring correctly, then it opens up a basket of problems down the road. So right off the bat, I want to talk about these minimum wage rules that have changed across the country. It's not something I'm going to get into in a lot of depth today because one, we did this in January where we summarized all the rule changes, but basically what's happening is that throughout the country, the minimum wage laws are changing and they're becoming very strict about and increasing the minimum wage hourly rate. And so it's important that you keep this in mind because it's not just the state that might be changing, it might be your county and your city. And we had a very recent client of ours who came to us that was being sued, unfortunately, by an employee because their payroll company, was one of the big three, had failed to notify them that they were paying under the minimum wage rules for their county. Now, that to me is just totally unexcusable. Now, they used the top three payroll company, hoping that they would be compliant. But as I've mentioned over and over and over again, these payroll companies out there are not HR compliance tools or HR compliance companies. They're just a payroll company. All they do is just process payroll, and that's it. I know some of them talk about being HR compliant, but as you can see from this example and many, many others, they are not, keeping an eye on your HR compliance as HR for Health does. And so issues like this come up. So to be your own advocate, I highly recommend you check to see what your state minimum wage rules are and your county and sometimes even your city minimum wage laws, because they do differ, right? They do differ and they can change pretty quickly. And so it's really important that you keep an eye on this. Now, some states are worse than others. In California, almost every municipality or county has changed their minimum wage rules. So please keep an eye on that if you are here in California. If you're not in California, please keep an eye on your state ones, and also, like I mentioned, your county and city, and figure out exactly how much you're supposed to pay. Now, many of you are probably thinking to yourself, well, I'm paying way above minimum wage, so I don't have to worry about this. But minimum wage impacts so much more than just someone's hourly rate, right? If you have exempt employees, for example, in many situations, they have to be paid double minimum wage. And so, those numbers can vary pretty dramatically. And so it's really, really important that you have a firm understanding of what your minimum wage hours are. Now, in some counties, I will be honest, you are paying pretty close to minimum wage, and so you have to kind of keep that in mind as well, because it's not as if you're paying a ton more. And so if the minimum wage obligations go up by 50 cents or so, you may already be in the negative there. So just something to keep in mind, something very basic, something that we don't really think about very often because it's just not something that many healthcare practices worry about. But under the circumstances, especially with inflation and other things happening, these numbers are going up, and so making sure that you're paying people correctly is vital. All right, let's jump into some specific state rules now, because as you know, these rules vary state by state. So we're going to run down a whole bunch of different rules. Florida's E-Verify laws have changed, and they've also have additional immigration measures that have taken place. So as of July 1st of this year, Florida now requires private employers with 25 or more employees to use their E-Verify system. Now, this is very important, right? This is very important because a lot of you are under that threshold, and so that's fine. But many of you, especially with having multiple offices and many group practices that are coming online, you're going to be above 25. And so it's important that you know that you have to use this E-Verify system to verify an employee's employment eligibility. Now, some questions that we get is, well, I have 5 corporations, and these 5 corporations each have 5 employees, for example, or 6 employees. Do I have to aggregate these? And the answer to this is, in almost every state, the answer is yes. If you own more than 50% of any entity, any corporate entity, you have to add those employees up together as a pool. And the reason is, it makes sense. The law is created in a way so that people can't just circumvent these rules by setting up corporations left and right. So if you own more than 50%, you have to aggregate. So if you have 5 offices and you each have, let's say, 6 employees, you have 30 employees in total. Okay, so just kind of keep that in mind. But this is a very new rule that just went into effect in Florida, so keep that in mind. In New York City specifically has limited automated tools in hiring. So effective July 5th, a New York City employer or even an agency may not use an automated employment decision tool to screen a candidate or employee for an employment decision, unless the tool itself has been subject to some sort of bias audit within the last year. Most haven't, but let's just say that's out there. If you have gone through that, then you're safe. But most tools don't go through that. And then the employer that uses the automatic employment decision tool must also provide notice to the employees and the candidates at least 10 business days before use, and must allow that candidate to request an alternative way of being selected, okay, or accommodated. So again, a lot of notice requirements and whatnot. Now the violations are pretty hefty, right? So you may have civil penalties up to $500 for the first time you do this, and then $1,500 for any subsequent violations moving forward. Again, most of our doctors don't necessarily have these tools in their offices, but what's happening is that there are a lot of third-party providers that are trying to earn your business by saying, hey, here's a hiring tool that you can use to automate this and automate that. You just have to be very, very careful that you're using something that fits within these bounds, because the penalties are all on you and not on them necessarily. So just kind of keep that in mind. Now there's, as you guys know from last year's presentations, that pay ranges have changed dramatically across the country, and now pay range postings are now required in some additional states as well. Specifically in 2023, Albany County in New York requires pay ranges to be in the job postings. The good news is that HR for Health has very specific job descriptions that allow you to document those job duties that are expected from the team, and then you can add those pay scales for the job posting. Now, this is becoming a frequent thing around the country, so just kind of keep that in mind. As you can see from the slide, California, Colorado, Connecticut, Maryland, Nevada, I mean, these are all states that currently have it. And it's only going to continue, sort of expanding. So just kind of keep that in mind. Again, and HR for Health has all these specific job descriptions, so you don't have to recreate them. They're all there and they're ready to go for you. So again, super easy, and then you can add your pay scale at the bottom. All right. Okay, let's transition a little bit and talk a little bit about what's been happening around the country in terms of non-competes and non-solicitation agreements. And then we'll talk a little bit about pregnancy and lactation updates as well, because we're seeing some movement there. So many of you may have been hearing about changes to federal law regarding non-competes and non-solicitation agreements. So some states like California and some others totally outlaw non-compete with regard to employees. What that means is that another employee or one of your employees can leave and open up a competing practice next door to you, upstairs, downstairs, almost anywhere. Okay. So in some states, it's totally unlawful to begin with. Some other states allow it on a limited basis, So there is a change happening where the federal government is coming in and hoping to basically make this into a national law whereby non-competes are illegal sort of everywhere. Now, it doesn't mean that employees or doctor associates can go and take your patient charts or patient information and use that in their own practice. It doesn't mean that they can take your staff even, if they're an associate. There are things you can put in employment agreements to protect yourself, and if you guys want that, let me know or let HR for Health know, and we'll work with you on getting you an updated employment agreement to protect you. But these are things that are happening, or things that you can do to protect yourself, even if the federal laws do change as far as non-competes are concerned. So keep that in mind. Here's a couple of them, right? So Indiana has amended their physician non-compete agreement law. So effective July of this year, July 1st, the amendment to the law basically prohibits an employer from entering into a non-compete with any primary care physician, and that's new, right? That's something that's very interesting, and so it's become totally unenforceable. Now, what's interesting about this is that not only is it that Indiana is following some of the more blue states, if you will, in terms of outlawing this, but that it's happening in Indiana itself, right? This is not New York, it's not Florida, this is Indiana. And so what that tells me is that if Indiana is doing it, what's going to happen is that we're going to start seeing a lot of other states in the Midwest, and then it's going to kind of expand into other areas where this is going to be unenforceable. So kind of just keep that in mind. That's really important. Now, those contracts that have been entered into on or after July 1st, they can provide a physician the right to purchase a release and require the employer to negotiate a predetermined price, if you will, a reasonable price for that release, if need be. So there is a little bit of a caveat there, but just kind of keep this in mind that these rules are changing pretty dramatically. Now, in terms of lactation, we are, seeing changes there as well. And so there are some expanded, remedies under, what called PUMP for nursing mothers, takes effect. So if, this was actually something that went into effect on April 28th of 2023. But employers who violate the PUMP for Nursing Mothers Act may be required to provide relief in the form of employment, reinstatement, promotions, lost wages, and potentially liquidated damages as well. And so, there are some steps that the employee has to take. If they have a complaint, they have to notify the employer, and then the employer has 10 days to rectify it, and so on and so forth. But, if you retaliate against an employee, for example, and you terminate them for using, or trying to exercise their rights under the PUMP Act, then those, opportunities to correct the situation may not be there, and you'll have different liabilities. But it's important to note that, again, this is a new thing that is, changing. And where we're seeing is some cities and some states like New York are expanding those accommodations. And so as of June 7th of this year, New York employers had to provide a location for nursing employees to express breast milk that is close to the work area, well lit and private. Okay. Now, many states have a lot of these rules already, but it's interesting that New York is just jumping into this. Now, it's important to remember that the location can't be a restroom, it can't be a toilet stall. It has to have a chair, some sort of working surface like a desk, and then access to running water and an electrical outlet. Now, the running water is potentially a slight problem because many of you, allow your team members to express milk in your private offices, for example, because sometimes it's the only room that has sort of a lock, it's private and so on and so forth. The rule is access to running water, not necessarily that there has to be running water in that room. At least, not the way we're interpreting it. So just keep that in mind, that, you do need to provide that. Now, many states already have these rules, so just kind of keep that in mind. But in New York, that is an expansion. And again, we're expecting this to happen, in many, many more states, especially states that don't have this. So the key takeaway from this second section of what we were just talking about is make sure you're, super aware of the non-compete and non-solicitation agreements in your state and the rules there. If you have an employment agreement with your associate that doesn't have any protections for intellectual property, let us know and we will get one for you. If you're an HR4Health customer and you would want one of these, you get a pretty significant discount from our law firm to put that together for you. So just make sure you raise your hand and you let someone know at our firm that you are an HR4Health customer. For those of you that are not HR4Health customers, it's super important that you become an HR4Health customer for the reasons we're just talking about, right? Making sure that you have the most updated contracts and that you're complying with all these pregnancy and lactation, accommodation changes that are happening, because we can put these all in your employment manual and make sure that you're aware of them. Again, these payroll companies are not doing any of this, okay? So don't rely on them for that. All right, some other things that are changing nationally, and this is very, very important for everyone to know, something called the Pregnant Workers Fairness Act. It takes effect or took effect on June 27th of 2023. It's a federal program that requires employers, those with 15 or more employees, to make reasonable accommodations for the known limitations of their employees that are due to pregnancy, childbirth, or other related medical conditions. Okay, so this is super important because this puts a huge obligation on many of you here, because the average practice that we work with has somewhere between 8 to 15 employees. And so you just have to kind of keep that in mind. If you're a group that's listening to this, you're going to have way more than 15 employees. And so you're going to have to abide by this federal law as well. And so these are reasonable accommodations. What are we talking about? Well, what we're really talking about is having extra time to sit or drink water, potentially be closer to parking if that's an issue, have flexible hours, appropriately sized uniforms, and scrubs and whatnot to protect the employee. Some safety apparel, if they're taking X-rays, and although there's no research regarding nitrous having any sort of negative impact on pregnancies, there is still this fear that nitrous does potentially cause some issues with pregnancies, and so making sure that you're accommodating for that. Additional break time potentially, leave or time off, for the child, for recovery from childbirth or related, disabilities, and then being excused from strenuous activities or some other kind of exposures that they may be exposed to in the practice. So again, it sounds daunting when you see it, but and it can be in many ways, but it's something that you absolutely 100% need to keep in mind, especially if you have 15 or more employees. Now, we wrote a pretty incredible white paper on this topic. If you want to take out your phones and take a picture of this QR code, you can get this, this poster that we have that kind of details everything regarding, the Pregnant Workers Fairness Act, and then you will also get a white paper that we're putting together after the fact regarding this as well. But the poster is a really great starting point for you. So make sure you take out your phones, take a picture of that QR code. Put in your email and you'll get it automatically, and you can refer to it later. Don't read it right now, read it later. All right, so how do we help with some of this? Well, HR for Health, the software, takes into account all of these leaves of absences. So we can track all of this for you in one place, so it is absolutely clear and there's no confusion whatsoever regarding what kind of leave it is, when they're taking it, how much time they have left, and so on and so forth. And so if there's one area that I see a lot of problems with that cause headaches for employers and then eventually employees, which is why people get sued, it comes down to time tracking and tracking of absences and vacations and things of that nature that are tied to benefits. And so these are two problem areas. And so if you can, it's another great reason amongst many reasons to sign up for HR for Health. All right, Oregon has amended its employer size calculations for the paid family and medical leave. So effective March of this year, March 16th, Oregon finalized a temporary rule that they had amending the definition of an employer size due to its paid family and medical leave laws. The rule specifies that in order to determine whether an employer is considered a small employer, the employer must calculate the employer size based on the average number of employees over a 12-month period. Okay, over a 12-month period. So it also includes calculation instructions for new employers in their first calendar year. But what's important about this is that now they're saying, look at your average over a 12-month, and then you make a decision about whether or not you're considered a small employer or not. Again, getting really into the nitty-gritty of that because people were playing games with that. Colorado has amended its family and medical leave benefit calculations effective March of this year as well, March 23rd to be exact. Colorado required that the family and medical leave benefit be calculated based on the earnings from all the positions held during the relevant time period, rather than earnings only from the job or jobs from which the employee takes the leave. So again, hugely important. Family leave continues to be a trend across the country. Various states are changing their rules, so please be on the lookout if in your state, as we will provide updates as we go on. Okay, so key takeaways here are Make sure that you're keeping an eye on your family leave trends across the states, because rules are changing quickly. If they do change and you're not sure how it impacts you, just call us at HR for Health and we'll help you navigate through all of that, because it is complex and can be very difficult to navigate through. Thankfully, we have the software, we have the data, and we have what you need to be able to do a lot of those calculations. But as you can see from this map and how the states are broken down, this is just going to be a matter of time before it expands. Remember, states are followers in many ways. There's usually a couple leaders in, on various topics, and then every other state starts to follow. And so just know that it's coming. All right, so staying ahead of it by getting on HR for Health is super important. All right, so let's talk a little bit about, in general, about some additional state protection laws that have gone into effect, having to do with sick leave, retirement, and some other discrimination type stuff. That's just important for everyone to know. In Arkansas, it's not prohibited to discriminate against hairstyles. And so, on July 31st, the Arkansas Civil Rights Act will be amended to provide that discrimination based on race, national origin, or ethnicity, racial animosity includes discrimination because of the natural and protective nature of someone's hairstyle. So that means that someone's hairstyle could lead you to a discrimination case for race or national origin or the ethnic racial background of the employee. Okay, Utah enables employers to obtain workplace violence protective orders now. So as of July 1st, Utah amended its protective order statute to allow employers to petition for and obtain workplace violence protective orders against individuals who have engaged in potentially workplace violence in the office, right? In the office. So, so this is a really strong tool because there are, sometimes things that happen if there is, violence in your workplace that is occurring. At least in Utah, you can now get a protective order from the court against that. So that's hugely beneficial. Usually, you have to investigate and potentially do some terminations and things of that nature. But to have something like this is pretty powerful and very interesting that it came from Utah. Georgia expanded its voting leave law, so effective July 1st, again, 2023, Georgia's voting leave law is amended to basically require time off to vote in person, okay, on a day that's designated for either early voting in addition to just election day. Okay, so it's not just on election day, but it could be for another day if they're allowed to vote early. And so that is really really interesting and something that I think came out of the last election and with some of the controversy that came around the election rules. All right, so what does our software do to help you with that? Well, obviously, we're going to give you all the updated policies in your manual. They're going to all be integrated in your software. And so you're going to have it all there. You don't have to worry about it translating over. So that's hugely beneficial. Again, we're heavily focused on HR compliance because we want to keep you out of court. And that's why everything is tied in together so smoothly. To talk about some sick leave law updates, as I promised you a couple of years ago, this continues to happen around the country where the sick leave laws are being amended and changed and added. And so now, as of February 24th, St. Paul in Minnesota has its ordinance, in terms of sick leave. And so, and Philadelphia has amended their supplemental regulations regarding sick leave. And so has, Bloomington, Minnesota. And so just kind of keep all these, these things in mind. If you have questions about, any of these ones in St. Paul or Bloomington or Philadelphia, just reach out to us and we'll walk you, through it. But there are definitely regulations and that apply. Also, as promised, the retirement obligations for 401k and others are also, expanding throughout the country and also expanding within the states that already have them. So if you have 50 or more employees in Colorado, as an example, you do have to register for this Secure Savings Retirement program. It's run by the state, but the program is going to sort of be launched in waves, if you will, based on their size. But with 50 or more employees, I think it's March 15th of 2023. Employers with 15 to 49 employees, it's May 15th of 2023. And employers with 5 to 14, it was June 30th of 2023. And so these rules have been sort of rolled out. And so if you haven't done anything with 401k or retirement, reach out to us, because we've got some really great solutions there, which I'll talk about in a second. The mains program with regard to 25 or more employees, effective April 1st of 2023. So just remember, there are guidelines there too. It's 25 or more employees effective April 1st. 15 to 24 employees October 1st of this year, and then 5 to 14 employees April 1st of 2024. Okay, 2024. So get ahead of this. I can tell you just from experience, if you're for those of you in Maine, that these deadlines come really quick, and it takes time to enroll everyone, and so it's a really good idea to do this sooner rather than later. And from our experience, those that jumped on it in the other states earlier were able to retain their employees, while those that waited ended up losing some of their employees because employees jumped to another office that was already providing these retirement benefits. So just kind of keep that in mind. Now, for those of you that want 401k, you want profit sharing, we have an awesome program at HR for Health. It's by far the leading program in the country for doctors. We have basically negotiated a deal whereby we are getting pricing for your 401k as if we had $1 billion under management already. And so what that means is that we have the lowest of the lowest rates, and groups all around the country, whether it's 1 offices or 20 offices, are switching to our 401k, and they're getting the lowest pricing. So they're getting thousands and thousands of dollars in savings. And the reason we're able to do this is we're able to pass it all on to you, right? Because we regard ourselves as an HR compliance company, and we're providing payroll, 401k, and some of these other benefits as add-ons to our core, which is HR compliance. But because it's not our core business, we're just passing on the savings to you, okay? We're not focused on that. We're focused on our HR compliance business, because that is the core. So you can't get the 401k without being an HR for Health customer, nor can you get payroll, because we know those are just, races to the bottom. We want to provide top service, but pass on all these savings to you. Most of these other payroll companies, they rely on the payroll business, they rely on the 401k business, and that's why they charge you thousands and thousands of dollars of fees. But thankfully, we're passing all that on back to you. So take advantage of it. It's right there for you. Now, for those of you that are worried about providing 401k or profit sharing for your employees, there's a whole different kind of process by which you can go through, where maybe you don't give provide funds to your employees, you don't match funds, you don't add money to their account, but you do have to provide it for them to contribute to their 401k. But for those of you who can't afford it, who you want to retain your employees, it's a great way to retain these employees. It's a great way of showing that you care about them. And the best part is, right, and this is something that no one will tell you, what you give to your employees in many ways would have been the same monies that you pay to the IRS in tax. So the nice thing about that in your practice is that instead of paying the IRS, you're paying your own employees, and you're retaining them and whatnot. Okay, and and this is something unique to medical and dental practices around the country. That's not necessarily the case for other companies like software companies and things of that nature. So take advantage of that. It's there for you. All right. let's shift gears again to security updates. So South Dakota allows electronic delivery of health insurance documents and notices now. So on July 1st, an employer or a sponsor, a policyholder of a group health plan may consent to electronic delivery of the health insurance documents on behalf of the employees or whatnot, which is great, makes things a lot easier. Virginia has restricted the use of employees' social security numbers. So again, as effective July 1st, employers are prohibited from using an employee's social security number as their identification number. It actually is a little bit surprising to me that Virginia is just getting around to doing this. This has been the case in many states already, but the employers must also not include the employer's social security number on any sort of ID card or anything that you may give them to enter the building or your office or whatnot. So just kind of keep that in mind, as there are civil penalties tied to that. Okay. All right. COVID related. Now, I hope, my wish is that when we do this again at the end of this year or maybe in January, that the word COVID does not come out of my mouth, right? I actually did do a presentation for a large state association a few months ago, and I couldn't believe it, but the word COVID was not anywhere in any of our slides. It was as if it was 2019. So one of these days, I hope to be able to do a webinar without using the word COVID. But as of right now, there have been some changes in California effective February. California's COVID-19 Prevention Non-Emergency Regulation Act replaced its COVID-19 prevention temporary standards, and so these are going to be effective through February 3rd, 2025. There's a whole bunch of record keeping requirements that you have all the way through 2026 actually. So just kind of keep that in mind. Idaho has prohibited COVID-19 vaccine mandates now, so effective April of this year. It's called the Coronavirus Stop Act. Prohibits businesses in the state from mandating vaccines against COVID-19 as part of their employment, unless of course the vaccine is a requirement by federal law, because federal law trumps state law. And so just kind of keep that in mind. It's very interesting. This applies to all business entities in Idaho, and so it will be interesting to see if other states follow suit. Because of Idaho leading the charge here. Florida on June 1st prohibits employers from requiring proof of vaccination or COVID-19 testing as a condition of working or being hired or whatnot, or a promotion or whatnot. And so there's that as well now, and that also kind of goes a step further, because they also prohibit discrimination for refusing to get vaccinated or tested or whatnot. And and it includes face coverings as well, I should mention. So that is very important to kind of keep in mind. But the face covering may not necessarily apply to you because there's an exception for healthcare providers or healthcare practitioners where it's a requirement as part of the safety equipment of the office. And so just kind of keep that in mind, as it may still be a requirement. All right, so as we end, what are the things you need to think about with regard to 2023 as we get to the end of the year? So a couple of very important points, because as we talk about this, over and over again, these are the kind of things that might get you in trouble. These are the things that we see our doctors being sued for before they become HR4Health clients. So I'm sharing this information with you because I want you to make sure that you are compliant and you've done everything you need to be to reach that goal, and that you're never on the other end of a lawsuit. Now, I know that many of you are looking at this and saying, well, I haven't been sued and maybe I won't be sued, and maybe should I do this? And the answer is, you're right. I mean, hopefully you haven't been sued, and hopefully you won't ever be sued. But the reality is that the odds are against you, and sadly, and because of that, there are some very basic things you can do to be compliant, right? So one is make sure you update your handbook with all the new laws, okay? And this is a very basic thing, right? You just absolutely need to make sure that your handbook is updated. If you have a handbook for someone other than HR for Health, where you have to spend thousands of dollars, updating it, you don't need to, because if you become an HR for Health customer, for that same fee, you will get that every single year for free as part of your service. So it's not just, you're not just paying for a manual, you're paying for our entire system, and you get the manual updated for you automatically for free. I mean, there is no better deal out there when it comes to the manual, because we all know we don't want to look at it, we don't want to deal with it. We did it, once or twice, and we don't want to ever do it again. And this is how we help with that. Number two is make sure you've updated your new hire checklist with all the new federal and state documents. On average, there's about 16 or so documents that everybody needs to have for every one of your employees. And so make sure you have that. If you go look in your files and you only have a couple of those, like 3, 4, 5, maybe, then you're way behind the 8 ball, and you need to get all of them. And now states vary. Some states have a lot more, like California, and some states have less, but the average is about 16 or so. So just kind of keep that in mind. There's a lot of them that are highly recommended that you get, even though they're not technically required. And so let us help you navigate all of that, right? Make sure you're compliant. And remember, your payroll company is not giving you any of these, right? They're giving you the basic federal ones, and maybe a state withholding one, and that's it. And and you're relying on them for HR compliance, which is really scary. All right, number 3, make sure your minimum wage is updated, with your city and county. I'm going to name some states where these rules have changed. This is the same state that were in January, so just kind of keep these in mind. So Alaska, Arizona, California, Colorado, Delaware, Illinois, Missouri, Maryland, Massachusetts, Michigan, Minnesota, Montana, New Jersey, New Mexico, Ohio, Rhode Island, South Dakota, Vermont, Virginia, and Washington. If you heard your state's your name, then please go look for your updated rules, because there has been some change at either the state level, the county level, or the city level. And I promise you, I did not read all 50 states. It may have seemed like that, but it definitely did not. So just kind of keep that in mind. If you heard your state, go check, because something has changed. Okay. All right. Reviewing employee certifications and trainings to make sure they are not expired. Super important that you look at this. It's a felony in many states to have an employee whose certification has expired and is touching a patient, right? So whether that's a dentist, RDA, DA, hygienist, optician, a nurse, a PA, I mean, anything, if you are being certified by the state and then you're touching a patient and your certification has expired, it's a felony for you personally and for the practice. And I'll tell you guys a funny story. We were recently contacted by an investor, and his wife was a dentist, and he's talking to us and bragging about the fact that his wife had let her license expire, and she was still working on patients, and she didn't realize it until like months and months later. I mean, it's like it happens even to super sophisticated people, right? But just don't take it lightly, right? Don't take it lightly, because it is a felony in many states to do that. So it's super important as the practice owner that you have an eye on this. And the nice thing is that HR for Health manages all of this for you. We track all of it for you. And so you will never be left out in the cold, because you'll know exactly when the employees need to renew their license. And if for some reason they can't afford it, or they forgot or something, then you can remind them, or maybe loan them money or something to allow them to get their certification if you choose to. But at least you'll know the information, you'll know whether or not to to let them work on those patients. Finally, make sure you're tracking the benefits and PTO correctly. If you're doing an accrual system, that you're accruing it, the system's doing it, correctly for you. We have the most sophisticated system at HR for Health when it comes to, accrual tracking of benefits, because it's tied to our time clock. And so it is hands down the best system out there. I can say that because it truly is, and especially because it tracks benefits. And we track it, and you can customize your benefits however you want, basically, on our system, which is very rare. And we did that because we work with doctors and we know that things differ, and you may have different benefits for different employees. And so that's where, we differentiate ourselves. So to end on a high note, how can we help you? Well, really it kind of comes down to these things, right? One is, we start with the handbook and make sure you are compliant there. We have payroll. If you choose to add payroll to with us, you certainly don't need to. You can stay with your payroll company if you love them, but don't pretend like they are an HR compliance tool. They definitely are not. But you have payroll. We have unlimited HR support and advising. So on a case-by-case basis, our team will protect you. It's available to you basically 24/7, and you can talk to them. And if they can't handle it, they will refer you to a law firm to help you with your question. Hugely important, hugely important. Then we've got documentation, of course, where all your documents are in one place. They're secure. It doesn't matter if your office manager quits or retires or gets mad at you and leaves or whatever. They can't destroy this documentation. It's all there. It's safe, and if you can transition from one person to another, and you're fine. You know exactly what you have. Our time clock, as I mentioned again, the best out there because it tracks benefits. It tracks so many things that many other systems don't provide. And the nice thing is that we do a lot of things in the background that employees don't realize when they're using our time clock that protects you legally. And of course, I can't share that with you, but I can tell you that none of the other practice management systems does it. No other payroll company does it, because they're not thinking compliance like me. There's a reason I'm a lawyer, right? There's a reason we created this, is to make sure that you're compliant. So hugely important, a lot of stuff on the back end. And then finally, for those of you that love performance reviews and want to build your team, we have our performance management tools, with reviews during the probationary period, during annual reviews, violation tracking, and then, God forbid, if they are not the right fit for your office, termination as well. All right. So we are your compliance partners. So please, take the time to schedule a quick demo with our team to see if it's a good fit for you in your office. It may not be, but it's worth finding out, so that you have that peace of mind of knowing you tried it. And if it is a good fit, then we'd be super happy and blessed to be able to protect you and make sure that you are safe and sound moving forward. All right. Well, thank you guys again for attending. I know there was a lot of information we went through. I hope you're having a wonderful, wonderful summer, and that you're not too sad that school's going to start in 8 weeks or whatever it is. But enjoy your summer vacations, and I hope to see you guys on the other side. And as always, please do not hesitate to contact us with any questions you have. All right. Thank you all.